Good afternoon, everyone. My name's Ivan Griscti. I'm presenting this CPD to have a few people here in person and a number of you on the live stream via the Level 22 Chambers YouTube channel. Before I get started, I acknowledge the traditional owners of the land on which we meet, the Gadigal people of the Eora Nation. I pay my respects to elders past and present. So what I propose to do this afternoon is essentially discuss a few key cases in the insurance and liability area from the last 6 months, say. There's essentially two decisions of the New South Wales Court of Appeal, one from the High Court as well. As it transpires, all cases in one way or another have a bit of a building and construction flavour to them. At the end of the presentation, there should be some time for some questions. Obviously, that's easy enough for those who are in the room with me. If you're watching it online, then you can ask a question either by making a comment on the YouTube page, I believe that's the case, or alternatively, you can send an email to my clerk, Jackie Charles. Jackie is obviously the Level 22 clerk, but I think if you're logged into the the YouTube page, that's the easiest way to do it. Obviously, if you're watching this, when I say hello, when I welcome people on the YouTube channel, I was in a sense meaning people watching it in real time. If you're watching it subsequently, well, if you want to ask a question, you're going to have to do that separately, perhaps by email to me even. So let's get started with the discussion. And the first case that we're going to discuss is one that's received a fair bit of comment, concerns the owners of Strata Plan 84674 and Pathburn, decision of the Court of Appeal from December 2023. And this concerns an action that's been brought under the Design Practitioners Act, a relatively new piece of legislation introduced in 2020. And really the focus of this matter, this case, is the interaction of that act with, well, if any, with the proportionate liability regime. Once upon a time, I had an unhealthily obsessive interest in proportionate liability. I've sort of weaned off it, but it's like a drug, you keep coming back to it. So just a quick refresher on proportionate liability. I'm sure we all know what it means, but for the present purposes, we're concerned with the regime of proportionate liability under the Civil Liability Act. Now, there's also other proportionate liability provisions in terms of with Commonwealth legislation as well. That's the Australian Consumer Law and the ASIC Act, but presently we're concerned with the Civil Liability Act. Proportionate liability applies to apportionable claims. Apportionable claims are claims for economic loss or damage to property where that arise from a failure to take reasonable care, but of course they cannot include claims for personal injury. They can also be claims for misleading and deceptive conduct under either the Fair Trading Act or the Australian Consumer Law. Section 34 of the Civil Liability Act introduces the concept of the concurrent wrongdoer. In old school language, that's a joint tortfeasor, but and the description in the Act of a concurrent wrongdoer is a person who is one of two or more whose acts or omissions cause damage or loss. Under Section 35 of the Civil Liability Act, the liability of a defendant who is a concurrent wrongdoer is limited to an amount reflecting the proportionate responsibility for the damage considered. And relevant for present purposes is Section 39 of the Act, which states that nothing in that part, meaning the part of the Act introducing proportionate liability, nothing in that part prevents a person from being vicariously liable for a proportion of any apportionable claim for which another person is liable. Section 5Q, this is, again, we're still on the Civil Liability Act, and that this under the heading of liability based on non-delegable duties, non-delegable duty. I can honestly say that since back in the early 2000s when these provisions were introduced, there's never really been cause to consider. I've certainly not had much cause to consider Section 5Q, but it's for reasons that will become clear. It is very relevant to the present action. Section 5Q relevantly states that the extent of liability in tort of a person for breach of a non-delegable duty is essentially to be determined as if the liability were the vicarious liability of the defendant. And this section applies to an action in tort. So the impact of Section 5Q is essentially saying, and this will be made clear when we were discussing the judgment, the impact of Section 5Q is that a tort based on non-delegable duty essentially excludes proportionate liability. So, as I say, this relatively new act, introduced in 2020, I think it was came into operation in about June 2020, the Design and Building Practitioners Act. And a key section is Section 37, extension of duty of care. That is, I'll use the term introduce loosely, it introduces a statutory cause of action. It says a person who carries out construction work, I should say construction work, is a very broad description. Virtually, if a dog goes near a construction site, it's more or less involved in construction work. Obviously, that's not true, but it is a very broad description. So if you're a developer or you're involved in a construction site, you're involved in construction work. A person who carries out construction work has a duty to exercise reasonable care to avoid economic loss caused by defects in or relating to a building for which the work was done and arising from the construction work. See subsection 2 there, it deals with the vexed issue of the duty, who the duty is owed to. So it's owed not only to a contractual party, but to subsequent owners of the land. So that deals with that potential issue of proximity. And subsection 3, which has got the kicker for the purpose of the present case, a person to whom duty of care is owed is entitled to damages for breach of the duty as if the duty were a duty established by the common law. Other relevant provisions, Section 39, it's non-delegable, so the duty must not be delegated. You're not entitled to delegate the duty. Section 40, you can't contract out of that part, you're stuck with it. Then Section 41, subsection 3, just to make things a bit more interesting, it just says it's subject to the Civil Liability Act. So, in terms of that's the sort of introductory background to the legislative background, I should say, for the facts of this case. We had an owners corporation that sued the builder, who was PAFBurn, and a developer called Madarina in respect of defective building works, and it was actually an apartment block. I should have pointed it out when the slide was up, but you would have seen an apartment block in the slide earlier. That was the relevant apartment block in Walker Street, North Sydney. And they sued under Section 37 of the Design and Building Practitioners Act, alleging economic loss caused by defects due to failure to exercise reasonable care. PAFBurn and Madarina filed defences, and often, as is in the case of construction matters, they pleaded the proportionate liability, and they said, in fact, they alleged there were 9 concurrent wrongdoers. So this case was actually, this decision, first instance, and and then subsequently on appeal, the first instance before Justice Rees and subsequently to the Court of Appeal was a notice of motion, and the Owners Corporation filed a notice of motion to strike out the proportionate liability pleading. Justice Rees, at first instance, dismissed the notice of motion. She held that the defendants were entitled to rely on the proportionate liability defence. And Section 5Q, which we touched upon before, of the Civil Liability Act, which the effect of which means that with a non-delegable duty, you can't rely on the proportionate liability defence. That didn't apply because the statutory cause of action under Section 37 of the Design and Building Practitioners Act was not a tort. You might recall that it said that this applies to a tort, whether negligence or otherwise. And so it's an interlocutory decision, so they needed leave to appeal to the Court of Appeal, which then they did do that. And the Court of Appeal unanimously upheld the appeal, in fact. And Justice Adamson and Justice Baston delivered separate decisions. The President, Her Honour Justice Ward, agreed with what they had to say. And there's some interesting discussion as to whether a statutory cause of action is a tort or whether it should be a tort. And they certainly essentially held that the breach of the non-delegable duty imposed by Section 37 of the Design and Building Practitioners Act is a liability in tort for the purpose of Section 5Q of the Civil Liability Act. Coming to that conclusion, and this is from Justice Adamson, the exercise, the consideration is not confined merely to what you might describe as common law torts and breaches of duty. Looking at the intention of the legislation, the legislative intent is to extend the scope of the common law duty to create a statutory cause of action, which is to be treated as if it was a cause of action in tort, and to the extent that it's relevant. And it's a fact that Justice Baston touches upon, because I think we're often told that not to put great importance on the headings of sections, but His Honour did observe that the heading did refer to extension of duty of care, and he thought that essentially, as he said, the duty imposed is an extension of an existing duty, and in any case, a cause of action for breach of statutory duty gives rise to a liability in tort. So to the extent that 5Q, so it comes within the scope of Section 5Q of the Civil Liability Act because it's to be treated as a tort. And then the Court of Appeal went on to consider the balance of the issues. Of course, we touched upon some of the relevant provisions of the Design and Practitioners Act. You recall Section 39 of that Act provided that the statutory duty under Section 37 cannot be delegated. And that, of course, means that the proportionate liability provisions, Part 4 of the Civil Liability Act, are excluded. So it means that the way that works is that the effect is that the builder is vicariously liable for breaches by concurrent wrongdoers due to the operation of Section 5Q of the Civil Liability Act. And that's sort of the mechanism by which that works. Now, whether they at any stage considered achieving that outcome by the use of plain English is not clear, but that's the way it seems to piece together. It's like a jigsaw puzzle, in terms of how you understand it. And so effectively is the liability owed by the respondents is treated as a form of vicarious liability, which is not subject to any limitation on their liability by way of apportionment between them and other concurrent wrongdoers. So the effect then of that judgment is really that it's quite clear. And I think in a case brought under the design Section 37, the breach of the statutory duty under Section 37 of the Design and Practitioners Act, a defendant cannot plead a proportionate liability defence. It's back to old school joint and several liability. So you can still, a defendant can issue a cross-claim for contribution still, but the protection that was provided was usually provided by the proportionate liability provisions is not present in this kind of case, and the judgments both of Adams and in particular of Baston go into a sense in their analysis. They take the view that, well, very much if you enjoy reading judgments where there's statutory interpretation and thing, then perhaps it's a judgment you will enjoy reading, because they look at how the two acts, being the Design and Building Professionals Act and also the Civil Liability Act, work together. They form the view that this interpretation was a harmonious one, and certainly that this interpretation, it was considered, was consistent with the legislative intent of the new Act, the Building Professionals, Design Professionals Act. So that's an interesting decision which will have, I think, a significant impact in design and construction cases. The second case I wanted to have a bit of a discussion about is Mere Force Proprietary Limited versus Allianz. That's a picture of I don't know how well people know their pub in the inner west. That's the General Gordon Hotel in Sydenham. And it's not looking too flash there, and that's because of the subject matter. There was a fire, and that's how it looked after the fire. That's the subject matter of this case. Just in case you don't know the pub, and I'm going to say I've not been there, but I've been to the website. And what can I say? It's another pub in the inner west that's been gentrified. So some people are sad about those things. I don't have any view either way myself. So look, what happened here? We've got, first of all, before we go into the facts, we'll just go through the relevant individuals or persons involved in the case. First of all, you've got, so General Gordon Hotel in Sydenham, they want to renovate it. You've got a principal contractor to do the works, a company called Rorig. And I should say all these companies, they're all related. But anyway, so Rorig is the principal contractor. You've got Rhino Strip Outs, and they are contracted by Rorig to undertake demolition work. So they're a subcontractor. So Rhino, let's call them Rhino. Rhino are a subcontractor. Then we've got Rhino engage Mere Force. I assume that's how it's pronounced, M-I-E. Mere Force. They're a labour hire company, and they supply the workers to Rhino to do work. Against that, there's Allianz, who is the insurer under a construction risks general liability policy. That's held, and the principal insured or the named insured is Rorig, and relevantly we'll come to this, but the definition of named insured, and hence definition of insured in the policy, expressly includes Rorig and its subcontractors, as well as employees and agents of such entities. So in terms of the facts that we've got going on here, so I think you recall we said Mere Force, they provided the employees to do the demolition works. Whilst they were doing that work, a fire broke out. We saw the effect of the fire. It damaged the hotel, but it also damaged neighbouring properties. So the neighbouring properties then brought a claim, or made a claim in negligence, and that's brought against Rorig, Rhino and Mere Force. Allianz says, look, yeah, we have to indemnify Rorig, we have to identify Rhino, but we deny indemnity to Mere Force. So then the effect of that is Mere Force applies to the Supreme Court for a declaration that is entitled to indemnity on the grounds that it falls within the definition of named insured under the policy. Case goes before Justice Peden at first instance, and there's some deliberation as to the meaning of the word agent, and the Mere Force arguing that, well, we don't need to, the term agent is to be used in its colloquial sense, and it's not, you don't need a strict legal interpretation of what is an agent. Someone who binds a principle. That's not really what this is about. Read in context, it's more someone who acts on behalf of someone else. Justice Peden was inclined to agree that it's not, the policy didn't use agent in the more formal sense. But she said, even if, in a sense, it doesn't matter whether you used it in the more formal sense or you adopted a broader construction, as in to mean any form of intermediary or persons simply performing the functions of others. Mere Force was not factually the agent of Rhino. What they were doing was supplying labour, supplying workers. They're not an agent. They're not acting on their behalf, not standing in their shoes. So they failed on that basis. And then there was an argument that the policy applied because Mere Force fell within the description of subcontractor of Rorig, because they're a subcontractor, and a subcontractor should be treated as a subcontractor. There's an English decision, I'll refer to it in the next slide, of Petrofina, where a court made that finding, and Her Honour distinguished that case on the facts on the basis it dealt with a different form of policy. And anyway, she held that Mere Force was not a subcontractor of Rhino, and the policy did not extend to a subcontractor. So they go to the Court of Appeal, and there's two issues essentially. First of all, the agent issue, and secondly, the subcontractor or the subcontractor issue. Now, three judges in the Court of Appeal, the President, Her Honour Justice Ward, and White, and Justices White and Kirk, they found against Mere Force on the agent issue, but there was some differences in the reasoning. Justices White and Kirk were of the view that, or in fact held that the term agent as used in the policy should be treated in its established sense as a legal term of art that's describing persons with the authority to create binding legal relations between a principal and third party. So very strict legal interpretation of agent in the context of the policy. Justice Ward, the President, disagreed to that extent. She said she held that the term should be used more in a colloquial sense, as someone who steps in the shoes of another for the performance of a particular role, rather than doing something for someone's benefit. However, on the facts, in a sense, this is similar reasoning, or adopting the similar reasoning to Justice Peden. The employees were performing their obligations to their employer, Mere Force. They were not, in a sense, acting as the alter ego of Rhino. So therefore, on the facts, even on the more, the less formal interpretation of the word agent, they weren't agents of the Rorig. Rhino for that matter. The subcontractor issue, the decision of Justice Ward, with whom White, on this issue, the court was all ad idem. Her Honour, the President, delivered the judgment on this issue, and Justices White and Kirk agreed. They said, Her Honour, that Justice Peden was correct to distinguish the Petrofina case, which I mentioned before. Petrofina was a case, 1984 Queen's Bench case, that concerned a very different form of policy. The court held that under that particular policy, a subcontractor was deemed to be a subcontractor. But as I say, that was a very particular type of insurance policy, and it related to a specific property. So the scope of that interpretation was very limited, was narrow. And this particular policy, it was much broader. It dealt with liability of the named insured or the insured at large in relation to any job. So essentially the court is saying, look, this interpretation, the effect of the construction proposed by mere force would render anyone providing services to another under an agreement with the other party's contractor as being a subcontractor, and that is just too broad. They're essentially limited the term subcontractor to such that it is literally just subcontractors and not subcontractors. But even allowing for that, it doesn't really matter, because the arrangements between Mere Force and Rhino was for the supply of labour, and this is not a subcontract. There's not work that was subcontracted out. It was simply a supply of labour. So as I interpret that case, even if the broader interpretation is right, that a subcontract is deemed to be a subcontract, well, they wouldn't have been successful anyway, because this was no subcontract of any form. It was just described as a supply of labour. So look, it's very fact-specific, that case, but look, interesting to see the interpretation that's put there, particularly in terms of the discussion as to the contextual interpretation dealing with the subcontractor issue, and the fact that it doesn't extend to a subcontractor, and distinguishing the Petrofina case, and even the discussion as to agency, where the court didn't agree on the principles, but they agreed on the facts. And as agency, as I say, two judges, and they were conscious of the context in which it seems to have been an insurance policy that was the subject of some negotiation and was very toing and froing. So they certainly took the view that it was very precise in what was chosen to be in the policy, and therefore was to be interpreted quite strictly. Now, the final case I wanted to discuss today is case of Zurich Insurance Company Limited and Copa and another. That's not a picture of the relevant building involved in the case. That's a picture of the Auckland skyline, but the relevant events occurred in the environs of Auckland. So yeah, so that's the justification for that photograph. So this was a representative proceeding that was actually, it started off as a representative proceeding brought in New Zealand. Copa was I guess you call him the lead applicant or lead plaintiff. He was representative of a number of owners in an Auckland apartment block who had sued a New Zealand company, the Brookfield Multiplex Constructions, in respect of defective design and construction of this apartment building. They obtained a sizable judgment against Brookfield. That judgment was partially paid, but note that 30 or 40 million outstanding before Brookfield went into liquidation. So they had a substantial part of that judgment unsatisfied. And then the plaintiffs brought proceedings in the Supreme Court of New South Wales against the insurers of Brookfield, seeking leave to proceed against those insurers in New South Wales under Section 4 of the Civil Liability Third-Party Claims Against Insurers Act. So relevantly, there's two pieces of legislation we need to keep in mind. First of all, because we've got events happening because of the New Zealand connection, the Trans-Tasman Proceedings Act from 2010, that's the result of a treaty between us and our friends in New Zealand. Section 9 of that Act permits an initiating document issued by an Australian court relating to a civil proceeding in that court to be served in New Zealand without the need for leave or satisfaction of any connection between the proceedings and Australia. And Section 10 provides that service of an initiating document in New Zealand under Section 9 has the same effect and gives rise to the same proceeding, as if the document had been served in the place of issue. So that's about, essentially, they certainly facilitate easy service of proceedings between Australia and New Zealand. And then, of course, let's call it the Claims Act, and it's unique to New South Wales. I still think that's the case. It replaced, back in 2017, there was a very cumbersome way of getting to an insurer directly at Section 6 of the Law Reform Miscellaneous Provisions Act. But this Act made it a lot more straightforward for a plaintiff to get their hands on insurance monies if for some reason there was a difficulty in suing a party itself. Section 4 of the Claims Act entitles a claimant who has a claim against an insured person to bring proceedings in New South Wales to recover from the insurer the amount of indemnity payable under the policy. Now, and it's something that the court must grant leave under the Act for the insurer to be sued directly. Now, the case, proceedings were brought in, as I said, the New South Wales Supreme Court, went before Justice Rain, and the case was argued on the basis of whether the plaintiffs were entitled to have brought the proceedings against Brookfield in the New South Wales Supreme Court. And this depended on whether in those notional proceedings, Brookfield could have been served with an originating process issued by the Supreme Court, and whether this would have been effective by operation of Sections 9 and 10 of the Trans-Tasman Acts. There was, as I say, went before Justice Rain, and then he found in favour of COPA, said, yeah, you can proceed against the insurers here. Went to the Court of Appeal. They also found in favour of the applicants. And the insurers went to the High Court. And the High Court also found in favour of the claimants. They rejected the insurers' argument that Sections 9 and 10 of the Trans-Tasman, just call it the Trans-Tasman Act, could not validly apply to an initiating document issued by the Supreme Court relating to a civil proceeding in a matter of state jurisdiction. So there was I can't possibly do it justice, so I won't even touch on it in terms of this constitutional argument. There was, obviously the usual intervention that occurs, and the issue is whether those sections of the Trans-Tasman Act, which were enacted under the power of the Commonwealth Government under Section 51(24) of the Constitution, Foreign Affairs, whether they could make that legislation which related to a matter dealing with state jurisdiction rather than one federal jurisdiction. The High Court unanimously rejected the argument of the insurers, albeit there are two groups that did so on different bases. Four of the judges, Chief Justice Kiefel, Justices Gageler, Gleeson and Jago, held that the service of process in proceedings involving the exercise of jurisdiction by a state court is within the power of the Commonwealth Parliament under Section 51(24) of the Constitution, irrespective of whether the jurisdiction exercised by the state court is state or federal jurisdiction. Justices Gordon, Edelman and Stewart had a more sort of, I hesitate to say it, but in a sense a more sort of simplistic approach to it, and didn't consider that the question was to be determined as to whether the putative proceedings could have been brought here, the proceedings that were brought in New Zealand, could they have been brought here? They thought that wasn't really the proper question. The real issue is whether the claim against the Brookfield or the insurer has a New South Wales connection. And in fact, yes, it did, because the jurisdiction clause in the insurance policy specified that the exclusive place of jurisdiction was the Commonwealth of Australia, and both Zurich and the other insurer, Aspen, are resident in New South Wales. So there was that connection with New South Wales. As I said, it's not the time or place to engage in a detailed discussion of the constitutional issues in the case, but what it does, I think, indicate at a very minimum that that there doesn't really have to be it only has to be a minor connection with New South Wales for a party in another jurisdiction to seek the benefit of, as I say, we'll call it the Claims Act, and the Claims Act is unique in New South Wales because, as far as I'm aware, no other state has such a legislation that has such allows a plaintiff with relative ease, provided there's a policy in place and the policy responds, to access the insurance funds, in this case because the defendant against whom judgment was obtained went to liquidation with, as I say, there was, I don't know what a New Zealand dollar is worth these days, but something over 30 million New Zealand dollars were outstanding on the judgment. Look, that was all that I wanted to discuss, but I'm happy to receive any questions, either, I don't know if you've received any online, Jackie, or from...
Not yet, but let me check. No, we can take a question from the audience.
Yeah, Jackson.
I've got a comment and then a question.
Okay.
My comment is about the Court of Appeal decision, mere force, I think you call it.
Yeah.
I suspect, though I can't confirm this, that it's actually supposed to be pronounced my force. And at the risk of digressing to something that's completely off topic and pointless, I'm just going to point out that I once had a client who, I think the name of his entity was supposed to be Alibi, and he had spelt it, he had misspelt it upon registration because he couldn't spell.
Yeah.
And the court kept calling it Alabi. It's A-L-A-B-I.
Yeah.
And I didn't want to sort of try and interject and get this
Alibi, yeah.
because I would have had to fess up that my client didn't know how to spell.
Yeah.
That's my comment. Anyway, the question is really actually relating to the Cobra High Court matter.
Yeah.
And it's really a procedural one, or a practical question, which is in circumstances where you may not know who the insurer is or whether indeed if the entity has insurance, what's the appropriate steps to be taken in those circumstances where you think that the recovery from that entity will be more or less impossible?
Well, look, that's a good question. So I'm not sure if, Jackie, would that question have been heard by people online? Or yeah, okay. So the question is, what do you do when you don't necessarily have the insurance details? And then you've got to look at the circumstances in which that can arise. Now, this is a case where proceedings were actually issued against the company. So you can, I would imagine, if the company's a party to an action and you have reason to believe that there is an insurance, that the company will not be able to meet a judgment and there is an insurance policy, I would expect that that's a proper basis to bring a notice to produce for production of the insurance policy. There's going back to well before this legislation, and there's always been a lot of argument as to whether a plaintiff is entitled to access or by way of or disclosure of a defendant's insurance policy. And the old school view was that, well, it's not relevant. But if there's a potential action under specific legislation, I imagine that certainly provides a basis to argue that it is relevant. Now, the circumstances under which that's in that kind of case where you've actually literally got a party, but there might be other circumstances where you want to access insurance funds. What if the company's already gone into liquidation? So whether there's a liquidator you can get a copy of the policy from or something along those lines, or and sometimes you're dealing with, if you're suing an individual and you just can't find them, that might be harder to find a policy. Yeah, but you know, I guess you have to do what you can. So Nick, were you gonna?
When I was a solicitor, I did asbestos litigation.
Yeah.
And we often have a question as to the insurance policies held by our client in the 1960s.
Yeah.
And there are firms that specialise in, they call themselves insurance archaeologists, and they specialise in tracking down historical policies. I mean, I think they go back to London sometimes, and I don't know how they track them down. There are companies that specialise in providing that service.
Yeah. Yeah. Well, that's interesting to hear. I as probably aware, it's not uncommon for me to be down in the Dust Diseases Tribunal in asbestos-related matters, and for that reason, because that there is applications are regularly brought under this Claims Act, because you know, asbestos claims, as evident from Nick's question, they can relate to exposure to asbestos products 30 to 40 years ago. So companies don't exist, they've gone out, they've deregistered or whatever. So yeah, if there is an insurer, if someone can find an insurer, then yeah, that provides a basis for bringing a claim under the Act. I mean, part of the problem with that is that the insurer, you might have to look at different remedies when the insurer becomes deregistered as well. But that's another story. I wonder if any other questions, perhaps? No? Okay. Well, look, thanks for your time. I think all three of those cases have certainly elements of interest about them. I suspect the first one that we discussed, PAF burn, is probably the most, will have a significant impact because, as I say, with proportionate liability, it's certainly a pleading that's prevalent in construction matters, and when you've got in a construction, a design and construction type cases, often many targets that can potentially share the liability, as evidenced by that particular case where the two companies sought to plead 9 other concurrent wrongdoers. But in a case that's obviously a positive one for plaintiffs bringing an action under that Design Act, then, well, it means that they can no longer plead proportionate liability in respect of that statutory duty under Section 37 of that Act. But look, if there's no more questions, I'll say thanks for your time and say goodbye. Cheers.